Companies Act Section 296, Comprehensive Powers of the Tribunal to issue financial calls on contributors during winding up proceedings. Section 296 of the Companies Act deals with the powers conferred upon the National Company Law Tribunal, NCLT, in the context of the winding up of a company. Winding up is a process whereby a company ceases to carry on its business and its affairs are wound up for the purpose of liquidation and distribution of its assets. This process includes the settlement of all claims and obligations, payment of debts, and division of any remaining surplus among the members or shareholders. To ensure the effectiveness and fairness of this process, the law provides the tribunal with specific powers to make financial demands referred to as calls on persons who are liable to contribute to the company's assets, known as contributors. This legal provision is particularly critical in circumstances where the available assets of the company are insufficient to meet the company's debts, expenses, and winding up costs. Subsection A. Power to make calls on contributors. At any point after the tribunal has passed an order for the winding up of a company, whether or not the tribunal has at that time fully examined or ascertained the sufficiency or insufficiency of the company's existing assets, it may proceed to exercise its authority to make financial calls on contributors. The term contributors refers to individuals, members, or other legal entities listed in the register of contributors who are liable to contribute to the assets of the company in the event of its being wound up. This includes present members as well as past members under certain circumstances, subject to limitations provided by law. The tribunal has the discretion to determine 1. Who will be called upon. This may include all contributors or only specific individuals' entities from the contributory list, depending on the need and the extent of their liability. 2. Extent of liability. The tribunal can only require payments up to the extent to which the contributors are legally liable under the Memorandum or Articles of Association of the company, or under other applicable legal provisions. No contributory can be required to pay beyond the unpaid portion of their shares or other contributions owed to the company. 3. Purpose of the call. The money collected through such calls shall be used for multiple objectives, which include settling the debts and outstanding liabilities of the company, including payments due to creditors, lenders, suppliers, or employees. Covering the entire range of costs, charges, and other necessary expenses incurred in the course of the winding up proceedings. Facilitating an equitable adjustment or redistribution of obligations among all the contributors so that the financial burden is shared justly and fairly, especially in cases where some contributors might have already paid or settled more than others. This provision ensures that the tribunal has adequate authority to mobilize funds needed to discharge the financial responsibilities of the company even if its own assets are insufficient. It provides a legal remedy that protects the interests of creditors and other stakeholders. Subsection B. Power to enforce payment through an order. Once the tribunal has made the call under subsection A, it is further empowered to pass an enforceable order directing the contributors to pay the amounts determined. This judicial order carries legal force and becomes binding on the persons named in it. The issuance of such an order ensures compliance and grants the tribunal the authority to take further action, including initiating recovery proceedings, if a contributory fails to comply with the order for payment. This adds legal certainty to the winding up process and ensures that the funds deemed necessary for closure and settlement can be reliably collected. The tribunal's order under this section functions similarly to a decree of a civil court and may be enforced in the same manner as a judgment for the recovery of money. It reflects the overarching legal principle that those who have benefited from the corporate entity during its active life may also be called upon to share its liabilities during its closure. For more details, contact us.